Hi guys, welcome back to my channel. This is Battle with Ola. My name is Mujola Olua. Thank you so much for stopping by once again. Today I want to talk about a very important topic that keeps coming up in my line of work. I'm a mediator, and I've just found out that most of the mediations that I've done in the last almost 2 years are tenancies, tenancy disputes, landlord tenant disputes, or tenant landlord disputes, as the case may be. So today I want to talk about notices to quit, or notice to quit, because I find that in most cases the notice that the landlord gives to the tenant is defective, and sometimes tenants hide under this to foment strife, for and with their landlords. So I want to talk about this so that landlords and tenants will both benefit, and so that laymen law students and lawyers as well can probably, join the conversation, leave me comments in the comment section, or learn a thing or two, or be refreshed in their memories, as the case may be. So what is a notice to quit? Notice to quit is the means by which tenancies are determined. It is a letter written by the landlord or the landlord's lawyer to or solicitor to the tenant, informing the tenant that the landlord does not wish to renew his tenancy after the expiration of the existing tenancy. And in cases where the tenancy has already been determined by probably a fluctuation of time, non-renewal of the rent, and what have you, a notice to quit also serves to formally, determine the tenancy, so that the landlord is not in the wrong as far as the tenant is concerned. What does the notice to quit do? It just lets you know the mind of your landlord as a tenant, so that you can begin to look for other options or alternatives of accommodation, as soon as the current rent expires, or if it has expired, for you to know that the landlord needs you to move out of his property. So it works for the landlord and for the tenant, in that it buys them both time for one party, to let the other party know that they are no longer interested in the contractual relationship between them. That's the landlord-tenant relationship, and to let to buy the tenant time to look for alternative accommodation. So it can be given on any property that is leased out or rented out. So it can be for commercial purposes, like a shop, an office space, or it could be, a residential property. A notice to quit is very important. Now, the law has set out, some guidelines or guiding principles. You can find it in the tenancy law, and you can find it in the Recovery of Premises Act. So I'm going to be using the Tenancy Law of Lagos. If you look at Section 13 of the Tenancy Law of Lagos, and if you look at Section 8 of the Recovery of Premises Act, it talks about, the period, the notice period for each type of tenancy. So for a yearly tenant, that is a tenant that pays per annum, that is maybe January to December, or maybe June to another May, or maybe August to another July, and as the case may be, the landlord needs to issue a 6 months notice, 6 calendar months. He needs to give the tenant notice for 6 calendar months before he can eject the tenant. For a monthly tenant, the landlord needs to give a 1 month notice. For a weekly tenant, the landlord needs to give a week notice. For a tenant at will, a tenant at will is a tenant that just moves into someone's property and is living in it at will, not at the pleasure or behest of the landlord. For a tenant at will, the landlord still needs to give them a 7-day notice, to quit. So the law has taken care of both parties. Now, notices to quit are not a license to live free in or occupy a property for free, because the law protecting the tenant protects the landlord as well. So essentially, the law is saying that, oh, you tenant, I'm giving you adequate time to look for alternatives, but in this within this period of notice, you still have to pay your rent, because the landlord needs to make profit from his property. So the landlord will not be shortchanged by giving notices. I found in my line of work that most tenants are misinformed. So they always think that when they are given notice to quit, or they are always demanding for notice to quit, thinking that this is a grace period for which they will not pay, and they would live in the house for free, and then they would use the money that they should have paid for that period to pay for an alternative accommodation. No, no, no. That's not the position of the law. In fact, an aunt of mine called me, a few years back, and she said that, the landlord had given them notice to quit and they had moved out of the property, having spent some time within the notice, which was out of their rent period. And then the landlord's lawyer had written to them demanding for the money for the time during which they held over. And then she was asking me that, is that the proper position? I was telling her, yeah, that's the law. You have to pay. And then she was like, why are you not on my side? Is that what you also say? It was funny because, at that point I was freshly, I think I'd spent 1 or 2 years at the bar. So it was like, you that you're my like my sister, you're also taking the side of the landlord's lawyer. I'm like, aunt, that's what the law says. You have to pay for the notice period. So the landlord will not be shortchanged because the law wants to protect the tenant. So those are the periods for which notices are to be handed out to each type of tenant. Now, even if a tenant has locked up the property and has gone away, but his possession of the property remains, that is, probably he has fixtures and fittings in the house, his goods, his things, or maybe he has even put someone in the house, or anyone or anything is in the house at his behest, this notice period must also be observed, even in its absence, before a landlord can fully eject him or, open the door, break into the door, and get into the house. Yes, I've done a video on this. It's one of my earliest videos on this channel. Please watch it. I know that there are people that have asked me about tenancies in time past, and I have referred them to those videos. I've done like 2 or 3 videos on tenancies, landlord tenant relations on this channel. I'll link them in the description box, but please do well to look for them and to watch them. Let me also say at this point that if there's any topic that you're looking for on the channel that you want me to talk about, before you make a request for it, please look through the channel. So these are the notice periods, under the law. Now, there's a provision that if there's a tenancy agreement, the landlord and the tenant, at the point of entering or executing a tenancy agreement, can agree as to the notice period aside what the law provides. That is, if the law says 6 months for a yearly tenant, you and your landlord can agree that, okay, I will give you 3 months notice, not 6 months. So if the tenant agrees and if the landlord agrees, at that point, it will override the provision of the law. But in the absence of such agreement, the law will take charge. So the law will take effect. And you can also execute tenancy agreements, reflecting what the law already provides. But essentially, if you have no agreement to the contrary, the law will prevail. So that is the position in tenancies. Another thing that most people misunderstand or misinterpret is the notice period. Okay, it is 6 calendar months for a yearly tenant. So where it say 1 month or 3 months or 6 months, it is calendar month. That is, you must count clear calendar month. So if you are given 6 months, for example, for a yearly tenant, maybe the rent is from January to December. So you have to give them the notice at least or at the latest by the end of June, so that it will start counting from July 1st to December 31st. That's 6 clear months. Another interesting thing to note is that you can issue notice to quit, which will go outside of the rent period. But the important thing is it must not expire before the rent period expires. When I'm saying rent period, I'm talking about the period for over which rent has already been paid. So if someone has paid for a year, maybe January to December, you cannot give them a notice that will start anytime before July 1st and that would end anytime before 31st December. You cannot give them such notice. It has to start sometime from 1st of July and count to December 31st. Then it can now start in August and count to January. It can start in September and count to February. It can start in October and count to March, and so on and so forth. For the period over which they've paid rent, the rent will cover that notice period, but for the period that they've not paid, they will have to pay. So if the notice period goes 3 months outside of their rent, they have to pay for those 3 months. That's the position of the law. And there are several decided cases because tenancies are highly litigated upon. Tenancy disputes are highly litigated upon, especially in this part of the world. You'd be surprised. So many people will take their landlords to courts. You know, during mediation, I always tell parties that the first thing that we need to ascertain or establish is that this tenant landlord relationship or vice versa is like a contract. It's a contract actually. So it's like going to the market and offering your goods. So if I say I want to sell my camera, for instance, and that's an offer. The tenant is the person that comes and says, I want to buy it. Then we negotiate the price, or if I want to lease it out, or as the case may be. But if I withdraw and say, I'm not selling, you cannot say, I want to buy by force. So you cannot force a willing tenant on an unwilling landlord. Just like you cannot force a willing landlord on an unwilling tenant. So once there's no consensus addendum, I always advise parties, let us look for amicable ways to depart and lawful ways too. So the first thing we need to always determine in a tenancy dispute is that as the consensus broken down, which party is saying they are no longer interested? Is it the landlord or is it the tenant? So if it's the tenant, if it's the landlord, that's when the notice to quit comes in. The law requires the landlord to issue notice to quit. Now, after the expiration of notice to quit, the landlord does not just waltz back into the property. No, he has to issue another 7-day owner's intention to recover possession. That's a notice given to the tenant again, saying that I'm counting 7 clear days from when you received this letter. After that, I will go to court, institute an action for recovery of premises, get a court order, and the court will come with me by the sheriffs and throw you out of this property, or throw your goods out if you are already away and it's just your possessions that are inside. Then I will lawfully repossess my property and I can do with it as I wish. Don't forget that in tenancies, the possession goes to the tenant while the ownership remains with the landlord. Now, let's talk about how to draft a notice to quit. Then I'll talk about the validity, because I had a mediation session that was very peculiar in the sense that the old man said that he had no problem moving out, no problem at all moving out, and he was going to move out, but he just needed the landlord's agent to agree and admit to the fact that the notice to quit was an incompetent one. You know, people are very funny. That's what he wanted. He wanted an admission, and I'll tell you why it was incompetent. But first, let's talk about how to draft it. Now, the notice to quit can be drafted by the landlord or by the landlord's lawyer or solicitor. So if it's drafted by the landlord will just go straight, introduce himself and talk about the property and that he wants the tenant out, the notice period, and every other thing he wants. But if it's by the solicitor has to introduce himself as the landlord's solicitor before he goes on to talk about what he needs to talk about. So usually it is drafted on a letterhead, although an ordinary paper will suffice. But if the landlord or the landlord solicitor has a letterhead, even better. The letterhead, which will tell us the address of the landlord or the landlord solicitor. For a lawyer, it will contain, your letterhead, of course, the name of your chamber, the address, phone number, fax, anything. And then we have the date immediately after the letterhead, and then the address of the addressee, that is the tenant, his address. After that, dear sir or dear ma, the notice to quit. It must be titled notice to quit. It must be unequivocally clear to the tenant what the landlord intends to communicate by that letter. That is why the title must be notice to quit. So you can embellish it and say notice to quit the premises located as so and so and so, but the heading must be notice to quit. Then the landlord starts, I, Mr. So, your landlord, hereby give you notice to quit and deliver up possession of the property, a 2-bedroom flat located at number 2, flat 2, number 2, so and so street, Lagos, which you occupy or hold of me as a tenant. Or the lawyer will say, I, Mr. So, or Mrs. So, acting on behalf of Mr. So, hereinafter referred to as my client and your own landlord, hereby give you notice to quit. Hereby give you notice to quit and deliver of possession of flat number 2, house number 2, street, Lagos, which you occupy as a yearly tenant. This notice period commences on the so date and ends on so date. So let them know when it's starting and when it's ending. So you must state the date when you want the notice to start counting and the day it will end, so that you can tell them that they are to pay up all utility bills and to restore the property or deliver a possession of the property in a tenantable condition, because the law is that a tenant must be given the property in a tenantable condition, that is, in a condition where he can live in it. So he must also deliver it back in a condition where another tenant or any other person can live in it. I talked about that at length in one of the videos I did on landlord and tenant relations. The link is in the description box. So that is it. After saying that, you can thank them, and then you put the closing salute, and then you put your name and that you are the landlord's solicitor or that you are the landlord. So there will be a live sample of a notice to quit at the end of this video. If you watch it to the end, you will see a live draft. That's how to draft a notice to quit. Now let's talk about the validity. For a notice to quit to be valid, these are the things that you should look out for as a lawyer when you're drafting. Then as a layman, when you receive it, look out for these things. If you want to contest it, these are the things you should look out for. Then as a law student too, these are the things you should look out for when drafting or when answering questions about notices to quit. First, it must contain the name of the parties, that is the name of the landlord and the name of the tenant. Then the proper description of the property in question must be there. House number 2, flat 2, a 3-bedroom apartment, a 1-room self-contained apartment located at number 2, Fiwajoye Street, Marwa, Lekki, Lagos. Like that, like that. But the property in question must be particularly described, and the date when the notice period will commence and when it will end must also be indicated in the letter, and then it must be dated and it must be signed. So in the mediation that I was talking about, the tenant said the reason why he refused to move out was that he wanted the landlord's agent to admit that he had served on him an incompetent notice because it was not signed. It was not signed. Can you imagine? The law is clear. There are the judicial decisions on that. An unsigned document is a worthless document. So the man wanted the agent, so the tenant wanted the agent to admit that you didn't sign this, it's worthless. So I showed it to the agent. Why won't you sign a notice to quit? Then he showed me other copies of other tenants that he had served and how they were dated, they were signed. I think that one was not even dated. So he said it was an oversight. So after the admission, we had way forward, we were able to make headway, and then we were able to resolve, and we entered into an MOU. The tenant agreed that he was going to leave, I think the next Friday or the next week. Within the next week, he was going to move out his properties. It was a commercial property, a shop, and leave. So, those are the things to look out for. Now, it's not advisable for you to start contending. Once you have served a quit notice, you should know that there's probably breakdown of relations between you and your landlord already. So you should be looking for amicable ways to settle it, to elongate your tenancy, or to buy some time, or just start looking for another alternative. But it's not the best when you start contending, a notice to quit and whatnot. But if you have to, if it buys you some time, or if it does you any good, these are the things to look out for to be certain that it is valid. And when it is an agent or a lawyer that is doing it, they have to let you know as part of the validity that they are doing it on the instruction of your landlord. They have to do that and let you know. And even if it's by a power of attorney too, they should let you know that they are acting based on a power of attorney, which I've talked about before. Please look for the video on power of attorney and watch it. So that's essentially all I want to talk about notices to quit. If you have any further questions, leave them in the comment section. I will be answering them, or you can mail me at houseoflivingstones@gmail.com. That's all I have for you in this video. I will see you in my very next video. Toodles.